gasps in the courtroom. Gasps as a federal judge raised serious questions about Trump loyalist Lindsay Halligan. Today's hearing lasted more than an hour, and a ruling from the judge could come at any time. A ruling that may conclude that Lindsay Halligan, who has never tried a case in her career, is not qualified to serve in her job and is legally not able to be in her job. And that means cases against James Comey and Letitia James could be over. Out front now, former Trump White House lawyer Ty Cobb. So, Ty, this was an important day. The hearing just over an hour about Lindsay Halligan and whether she's allowed to be in her job. Will Halligan be disqualified and her indictments tossed out?
She will be disqualified. The Comey indictment will be tossed out. And may not be able to be rebrought because the statute of limitations has lapsed. The James indictment is likely to be tossed out as well, but it can be rebrought, as Abby Lowell conceded.
Hey world, Adam is here. A federal judge just dropped a 130-page legal atomic bomb on the Trump administration, and the fallout is about to rain down on every criminal prosecution in New Jersey. Judge Matthew Brann, sitting by designation in the District of New Jersey, has had enough. And when a federal judge reaches 130 pages of frustration, you know things are bad.
A major legal loss for Trump. This is big news, and we're going to get into why it matters. A federal judge here quashing grand jury subpoenas in Trump's effort to harass the Federal Reserve to try to help him in the election. I'll explain, but bottom line, Trump loses, Federal Reserve Chair Powell wins. This is a blow to the whole thing. And in over 25 pages, Trump learned he is powerless to do the kind of legal harassment that he's trying. I'll just tell you some of the highlights coming out of this blistering rejection of what has been a pattern that you've probably noticed. Trump trying to use or abuse federal powers in the DOJ to go after anyone who disagrees with him. The judge writes, there's abundant evidence these subpoenas' dominant, if not sole purpose, is to harass and pressure Powell, either to yield to the president or to resign and make way for a Fed chair who will. He adds, on the other side of the scale, the government has offered no evidence whatsoever that Powell committed any crime other than displeasing the president.
This isn't about Alina Habba anymore. You remember her. Trump's personal lawyer who got tossed from the U.S. attorney position in New Jersey for being unconstitutionally appointed.
Federal appeals court unanimously rules against the Trump administration, agreeing that Alina Habba, President Trump's former personal attorney, is disqualified from serving as acting U.S. attorney in New Jersey. In August, a district judge ruled that Habba had been serving without lawful authority since she was tapped to temporarily lead the U.S. attorney's office there in the state. The judge said she must be disqualified from participating in ongoing cases. The Justice Department appealed that decision but lost the appeal. The DOJ has now exhausted the appeals process.
You'd think the administration would learn its lesson. You'd think they'd nominate someone, go through the confirmation process, follow the rules everyone else follows. Instead, they created a triumvirate. 3 people. 3 so-called inferior officers appointed by the Attorney General to collectively do the job of one U.S. attorney.
Breaking news, a critical test in the criminal cases against 2 of President Trump's biggest political foes. A federal judge in Virginia just heard arguments in a bid from James Comey and Letitia James to disqualify prosecutor Lindsay Halligan. Their attorneys argue Halligan was handpicked by President Trump and is serving as interim U.S. attorney for the Eastern District of Virginia unlawfully.
One handles criminal supervision, one handles civil cases, one handles administration. And Judge Brann looked at this Rube Goldberg contraption and said, absolutely not. On page 3 of his ruling, Brann delivers the line that will be quoted for years. 1 year into this administration, it is plain that President Trump and his top aides have chafed at the limits on their power set forth by law and the Constitution. Chafed at constitutional limits. That's now the official judicial characterization of this administration's governing philosophy. Not accidental overreach, not good faith disagreement about legal boundaries, chafing. Like the Constitution is an irritant. Like the foundational document of American democracy is somehow getting in the way of what they want to do. Brann goes on to eviscerate the administration's legal argument. The government claims that despite Congress's clear requirement of presidential nomination and Senate confirmation for U.S. attorneys, a requirement unchanged for 236 years, the Attorney General can just ignore all that and appoint whoever she wants through a tangled web of broad enactments using general language. This is what this suit is about, Brann writes. Power. Page 4 gets even better. The allocation of power among Congress, the President, and the courts to preserve the equilibrium the Constitution sought to establish. I conclude that the current leadership structure of the Office of the U.S. Attorney for the District of New Jersey exceeds the Attorney General's statutory authority to appoint inferior officers and delegate them powers, and therefore constitutes a unilateral appointment in violation of the Appointments Clause. Translation: what you're doing is illegal, plain and simple. You can't circumvent 236 years of constitutional practice by dividing one job into 3 pieces and calling them inferior officers. And here's where the nuclear option comes in. Judge Brann warns the government that if they continue any further unlawful attempts to fill the office, it will result in dismissals of pending cases. Criminal cases. Defendants will walk. Criminals will go free because of this administration's refusal to follow the Constitution. Let that sink in. A federal judge is threatening to let dangerous criminals out of prison because Trump and Bondi refuse to appoint a U.S. attorney the right way. There are currently 6 districts without a confirmed U.S. attorney. Some of the most important prosecutors' offices in the country: Eastern District of Virginia, districts in California, New Jersey, high-volume, high-profile offices handling thousands of cases, and Trump refuses to go through the confirmation process. Here's the hypocrisy that Judge Brann absolutely nails. In the Mar-a-Lago case, Trump's DOJ argued that because Jack Smith wasn't properly confirmed, everything he did was illegal. That was their position. That was the argument they convinced Judge Cannon to accept. Special counsel improperly appointed? Indictment invalid. Now the same DOJ stands in front of Judge Brann and argues the exact opposite. They say they don't need a confirmed U.S. attorney. They can just have 3 lawyers appointed by the Attorney General to do the job. 3 inferior officers handling criminal supervision, civil cases, and administration. Judge Brann isn't buying it. And he points out something called judicial estoppel. You can't take one position in one court and the opposite position in another court. The law has doctrines to prevent exactly this kind of gamesmanship. Law of the case. Res judicata, collateral estoppel, issue preclusion. They all mean the same thing. You had your day in court, you litigated the issue, you're stuck with your position. You can't flip-flop depending on what's convenient. Page 7 of the ruling notes that aside from the 3 appointments, nothing has changed about the New Jersey office's operation since Judge Brann first found Alina Habba's appointment offensive. They're still using funding under salaries and expenses, United States attorneys, to pay the triumvirate members. Nothing has changed except the names. Page 9 hits hardest. With all of the options that the government could use, including appointing one of the 3 to be the U.S. attorney for 120 days, putting somebody up for confirmation process through the Senate, why does the fate of thousands of criminal prosecutions in this district potentially rest on the legitimacy of an unprecedented and Byzantine leadership structure? Brann answers his own question. The government tells us the president doesn't like that he cannot simply appoint whoever he wants. Notwithstanding the chaos that pervades criminal prosecutions in this district, and without regard to the possibility that scores of dangerous criminals could have their cases dismissed or convictions eventually reversed, the executive branch, at least right now, is not prepared to use the legal options. Read that again. The president doesn't like that he can't simply appoint whoever he wants. So instead of following the law, he's created a Byzantine structure that threatens thousands of criminal prosecutions. And when a judge points this out, when he offers multiple legal options to fix the problem, the administration refuses. Brann points out this same unlawful structure exists in 5 other jurisdictions. 5 other districts operating without properly appointed U.S. attorneys. 5 other places where criminal cases rest on shaky constitutional ground. Page 11. I ignore any argument that the government offers based on the practical need to operate the office. Just fill the vacancy the right way. That's all the judge is asking. Follow the Constitution. It's not complicated. The history here matters. Alina Habba was appointed unconstitutionally. She got fired. Then the people who followed her got fired. Now we have 3 people doing one job, none of them properly appointed, and the judge has had enough. Judge Brann was brought into this case by the Chief Judge of the Third Circuit to sit by designation in New Jersey. Why? Because the local judges have a conflict. If there's a vacancy, the district judges can help fill it. But every time they try, Trump fires whoever they appoint like a petulant child throwing food from his high chair. So an outside judge had to be brought in. Now, on pages 129 to 130, Brann delivers his conclusion. Brevity may be the soul of wit, but not when it comes to legal decisions. For the above stated reasons, I conclude that the triumvirate has been unlawfully delegated the authority of the U.S. Attorney for New Jersey in violation of the Federal Vacancy Reform Act, the statutory offices its members purport to hold, and the Appointments Clause of the U.S. Constitution. Accordingly, they are disqualified from supervising the prosecutions of 2 cases that this arose under. He denies one defendant's motion to dismiss, but defers ruling on another, pending supplemental briefing. Then comes the warning. Recognizing the novelty of these legal questions, I believe that a stay of this decision is appropriate to ensure a speedy appeal. Take your appeal, he says. Let the Third Circuit decide. But here's the kicker. My reasoning makes clear that a stay cannot validate an unlawful appointment. If the government chooses to leave the triumvirate in place, whether there's a stay or not, it does so at its own risk. At its own risk. Meaning if they keep these people in place, if they keep violating the Constitution, he will entertain motions to dismiss indictments. Criminal defendants will walk. The jails will open. Now there's a side note worth mentioning. The Third Circuit has some recently appointed Trump judges, including one who was in the DOJ for months telling federal judges to go fuck themselves and is now a lifetime appointee. He should recuse. He absolutely must recuse from any case involving his former employer. Whether he will remains to be seen. But the core of this ruling is unmistakable. Judge Brann has laid out in 130 pages exactly why this administration's approach to appointments is unconstitutional. He's offered multiple legal paths to fix the problem. He's warned of the consequences if they don't. And the administration's response? Nothing. They keep the triumvirate in place. They keep violating the Appointments Clause. They keep chafing at constitutional limits. The phrase chafing at constitutional limits is going to follow this administration forever. It's the perfect description. Not accidentally exceeding authority, not pushing boundaries in good faith. Chafing, resenting, straining against, treating the Constitution like an annoying restriction rather than the foundational document of American democracy. Judge Brann has given the government a path forward. Appoint one of the 3 as interim U.S. attorney for 120 days. Nominate someone for Senate confirmation. Follow the process everyone else follows. But Trump won't do it because Trump can't stand any limit on his power, not even limits baked into the Constitution for 236 years. So here's where we stand. 6 districts without confirmed U.S. attorneys. Thousands of criminal prosecutions hanging in the balance. A federal judge threatening to dismiss cases and let defendants walk, and an administration that would rather risk dangerous criminals going free than follow the damn Constitution. That's the nuclear option Judge Brann has prepared. Not a bomb he wants to drop. A bomb he's threatening to drop if the administration keeps playing games. Keep the triumvirate in place, he says, and do so at your own risk. Your own risk meaning criminals walk. Your own risk meaning convictions get reversed. Your own risk meaning the chaos you've created finally lands on your head. The ball is in Trump's court. He can do this the right way. He can nominate someone. He can let the Senate do its job. He can follow 236 years of precedent. Or he can keep chafing, keep resenting, keep violating, and watch as federal judges start dismissing cases and letting defendants out of prison. Judge Brann has made his position clear. The Constitution isn't a suggestion. The Appointments Clause isn't optional. The Vacancy Reform Act isn't a joke. And the courts are done watching this administration pretend otherwise. 130 pages. One conclusion. Follow the law or face the consequences. The nuclear option is on the table. And the only question now is whether Trump is smart enough to step back from the brink before Judge Brann is forced to use it.